Okay, if everyone's happy, I'm going to make a start. Very warm welcome to all of you that have joined us for what is the second in a week of webinars that we are going to be delivering as a housing team. Some of you may know that we usually have an annual housing day where we have a whole host of topics relevant to people in social housing, and it's attended, and we host it at the inn, and it's a lovely way to catch up with many of our valued friends and colleagues. But the advantage of a webinar is we've been able to reach many more of you, and it's one of the reasons why I've delayed starting today, because we have several hundred people signed up to attend today's webinar. For those of you that don't know me, my name is Kuljit Bogle, and I'm a public law barrister at Cornerstone Barristers, and I jointly head up the social housing team. And I'm joined by 4 of my colleagues today, all of whom are also members of the public law team and are experts in both social housing and in court of protection matters. Before we get going, I'd just like to remind you that we have got a whole series of other events happening during the course of this week. And that's what the schedule looks like for this week. There's still scope to sign up for those events if you haven't already. So if you are interested, please take a look at our website. You'll be able to get the details for how you participate in those events on the website. And in addition to forthcoming events, you can also access recordings of webinars that we've already been doing over the lockdown period. And there's a whole host of topics that we've already covered that may be of interest to you. The other thing to note about our website is there is an ability to sign up to our housing newsletter and any other newsletters that you might be interested in, and that's on the front page of our website. So please take a look and sign up for the things that are of relevance to you. There's going to be a Q&A a function on this webinar, and you'll see a tab which will allow you to ask questions during the course of the webinar. Please make use of it, and the speakers are going to be doing their best to answer questions as we go along, as well as to have some dedicated time for Q&A at the end. I can't promise that we'll get to all of the questions, and those that are specific to cases, you might wish to follow up through a set of instructions or an individual email, as opposed to things that we'll try and deal with things that are of more general relevance to as many people as are participating today. This webinar is being recorded, as you will have seen from the slide at the very beginning, and the recording will be made available on our website, and copies of the slides will be emailed to you after today's event. The last thing to say by way of housekeeping is that we are very interested to hear your feedback on today's event, and indeed any of the events that you participate in that Cornerstone hosts, and we very much use that feedback to inform the future events that we put on, not only in relation to format, things like time of day and the like, but also content. It's really useful to know from you what you would like us to cover, because that will very much form the basis of our discussions of how we formulate our programme going forward into 2021. So please do provide feedback as and when you get the email inviting you to do that. Before I hand over to speakers, I can't host chair a webinar without making reference to our books. We have a number of expert authors that have produced books on various topics within not only the social housing field, but more generally the areas that Chambers covers. Do take a look at those, and I'm really pleased to be able to say that we've been ranked as a top tier set by the Legal 500 again, and we've got no less than 12 members who've got individual rankings. So you are in for a treat, and you're about to hear from some real experts. And what would sets us apart from housing lawyers, other housing lawyers, is that we not only have the expertise in housing, but we have experts that have that knowledge, as well as knowledge within the court of protection field, equalities, public sector equality act duties, and indeed the whole host of issues that local authority and social housing landlords face. And we really are in for a treat. There are 4 speakers today: Michael Paget, John Holbrook, Peggy Etivet and Tara O'Leary, each of whom will speak Each session will be for about 15 minutes with a view to having some time at the end to answer questions that have been posed through the Q&A function. So that's all I propose to say by way of housekeeping, and I'm going to hand over to Michael, who's going to deal with the first topic, the role of the Court of Protection.
Thank you, Kuljit. I'm going to speak about what is the Court of Protection and how do you get a case up and running in the Court of Protection in the context of a difficult housing, antisocial behaviour type case. It sounds like the Court of Protection is something from the Game of Thrones, but it is really a court that does exist, and it is relatively new. It's superseded the Supreme Court following the Mental Capacity Act 2005. That act governs how the Court of Protection works, and it also governs how people that are assisting someone who lacks capacity needs to behave. The statutory principle that governs the Mental Capacity Act is that there is a presumption of capacity on everyone unless you can prove otherwise. So you might have a client who's a tenant who's very, very difficult, but they may well have personality disorders, but unless they are incapacitous, then you can't utilise the Court of Protection. The presumption is everyone's capacitous until you prove otherwise. You don't always need the Court of Protection. There are some scenarios where you can act under a general authority under Section 5 of the Mental Capacity Act, which gives a party a general authority to act in relation to the care or treatment of P when it is necessary to do so. And this will usually suffice unless the decision is so serious that you need the court itself to make the decision. You will most probably need the court to make a decision in relation to termination or entering into a tenancy. What is the constitution of the Court of Protection? It is part of the High Court under Section 47, and it is under Section 46 a Superior Court of Record. It's presided over by the President of the Family Division, Lord Justice McFarlane, with the Vice President, Mr. Justice Hayden, running the Court of Protection on a day-to-day basis. Under his authority, most of London work is dealt with out of First Avenue House, and the senior judge at First Avenue House is Her Honour Judge Hilda. High Court judges are Tier 3 judges, circuit judges in London and outside London, if they have a nominated Court of Protection ticket, are Tier 2 judges, and then the district judges in First Avenue House are Tier 1 judges. The rules of the Court of Protection are governed by the Court of Protection Rules 2017, augmented by the CPR. It is a completely different type of court to the county courts because the purpose is inquisitorial, not adversarial, and this sometimes may help with a difficult tenant where a lot of the activity is being initiated by the court itself. The court is being proactive, so it isn't a clash between landlord and tenant. And so sometimes that can, as a matter of psychology, help in getting the court to understand how difficult the situation has become for the landlord. All that the Court of Protection can do is make a decision that the patient themselves could have made if they had capacity. So in this context, the Court of Protection can replace the patient to take the decision to terminate the tenancy. But you can't use the Court of Protection to do lots of other types of decisions for the patient, including you can't, for example, get the Court of Protection to vote for the patient. So the first hurdle that you need to overcome to be able to run a Court of Protection case is to determine that the patient does actually lack capacity. It is the capacity for that specific type of question. And in the context of an ASB tenant, you are going to need to have evidence that they can't litigate, they can't decide where to live, probably, and they can't enter into or terminate a tenancy. Kuljit, can you put the next slide on, please? In determining that, it's decision specific, and it requires the patient to be given as much assistance as possible to be able to weigh and balance all the factors in a decision and understand those factors. It's the process of reaching a decision which the patient can't do. If the patient can do that, but then makes a very, very poor decision, they still have capacity. So an example of that would be if the classic exemplar of that is where you've got a Jehovah's Witness. They know that if they don't accept a blood transfusion, they're going to die. That's a very, very unwise decision, but it is a capacitous decision. They understand the consequences, they've weighed everything up, and they realize that there's a high risk of death. It's still a decision they're entitled to make. It's a very bad decision, but it's a decision they're entitled to make. So that's the limit of the paternalistic role that the Court of Protection has. It can't start entering into value judgments about what a person is doing, but if a person can't process and reach a conclusion themselves, then they lack the capacity. So in the context of housing, the question is going to be, do they know that they've got a tenancy? Do they understand that if they behave in a certain way, that's going to be a breach of a tenancy? And do they understand that if they did that, that there's a risk of the loss of accommodation because the landlord is going to come along and terminate or seek to terminate their tenancy? If they understand all that, then they're just making very unwise decisions. If they can't balance all that, then they're incapacitous. You've got the gateway, you've got over the first hurdle, and you can run a Court of Protection case. I'll hand over now to John to deal with the next steps in a Court of Protection case.
Thank you, Michael. Could we have the next slide, Kuljit? Yeah, so I'm just going to develop this issue of capacity, which Michael has outlined, and say a bit more about what it really means in the context of a housing case. Because in very broad terms, it's does the person have capacity to decide to keep, hold, or surrender a tenancy? And Section 3 of the Mental Capacity Act directs us to have regard to 4 issues essentially, which are: does the person understand relevant information? Secondly, can they retain that information? Thirdly, can they use and weigh that information? And then fourthly, can they communicate it? Now, in the context of holding a tenancy, it's those words use and weigh which are particularly important. It's relatively easy for a person to have a formal or a technical understanding of what a tenancy means. So typically the person will say, this is the person who may or may not have capacity, will say, if I have a tenancy, that means I don't own it. It means I have to pay the rent. It means I mustn't make a noise or disturb neighbours. So the person may have a formal technical understanding of what holding a tenancy means, and they may also be able to retain that information in the sense that if they were told it, they'd be able to recite it back to you a minute or two later. But the real test, and I think this is the part of the test which is often overlooked, is the question of whether or not the person can actually use and weigh that information. It's particularly the use of that information which is important, because in the context of holding a tenancy, that means, does the person appreciate that he cannot manage his own tenancy? Does he appreciate, for example, that although you have to pay the rent, he's not actually able to pay it, or he doesn't remember it for long enough to be able to pay it, or he knows he's not supposed to cause a noise or a nuisance, but actually he does, for whatever reason. The problem is he's not able to really use that formal understanding of a tenancy. Or quite typically in the context of a person who has dementia, they will say they are able to look after themselves, take the bins out and do all the things that tenants would ordinarily do around the house. But in the context of applying that test to themselves, they fall short. So it's really that question of whether they are able to use the information, which is the acid test of whether or not they have capacity to hold a tenancy. And I think probably we can all think of cases we've been involved in, which have been proceeding down the county court route, where actually it's also clear that we're dealing here with a person who doesn't actually have capacity to hold a tenancy. So next slide, please. So with those introductory remarks in mind, what does that really mean about what sort of housing cases should be in the Court of Protection? Because you frequently have a choice. You can seek a possession order in the county court, or you can go to the Court of Protection. And the Court of Protection does have the power to authorize somebody, typically the landlord or the local authority, to terminate that tenancy on the tenant's behalf. But there are really two conditions that you need to think about before proceeding in the Court of Protection. The first condition is one of law, which is this issue that Michael and I have just been talking about, which is that does the person have the incapacity to make that decision for him or herself? That is a legal requirement. And if the person has capacity to make that decision, then there's no point where you cannot go to the Court of Protection. But if the person does lack the capacity, then there is actually a practical issue that needs to be confronted, which is to ask yourselves, is there an alternative for this person's residence? In other words, if they do surrender their tenancy, is there a realistic alternative as to where they are going to live? I've said that's a condition of practicality because in fact you won't find that in any statute, because the statute simply says that the decision taker, the Court of Protection, has to make a decision in P's best interests. But in reality, it would be very difficult, and I find it very hard to think of a circumstance in which the Court of Protection would find it in P's best interests to surrender a tenancy and not have anywhere else to go to, because you're invariably talking about someone who has some sort of vulnerability, which is why they lack capacity. And in those circumstances, it's difficult to see how a court could be persuaded that it's in the P's best interest to surrender a tenancy without an alternative. Bear in mind as well that you wouldn't get very far by saying, but they can make an application as a homeless person, because the likelihood as well is that if they don't have capacity to hold a tenancy, they wouldn't have capacity to make a homelessness application. I didn't refer to it in the slides, but it's the case of Firdaus Begum and Bexley. It was decided in 1993, and that's in the appeal cases at page 509. So long as you've got a person, you're dealing with a person who lacks capacity to hold a tenancy, and in reality you have some sort of alternative, what are the benefits of proceeding in the Court of Protection? I think the key benefit is that there is just one issue that everyone has to focus on, and that is what is in P's best interests. Is it that they live in their current accommodation, accommodation X, let's call it, or should they move to accommodation Y? Michael mentioned that the proceedings are not adversarial, and that undoubtedly does inform the general ethos of the court and the way that the parties respond to one another. So my experience of county court, say, nuisance cases is that you plead all your allegations, you get a defence that usually denies or doesn't admit most or all of them. So you're immediately in an adversarial situation where you have to then bring your witnesses to court and prove your case. You then have to focus on a whole gamut of other issues under the rubric of is it reasonable to make a possession order, and so on and so forth. It's much more straightforward in the Court of Protection, where the court's simply interested in should this person live in accommodation X or accommodation Y. And so the third bullet point here, the hang-up which I think informs many judges in the county court, which prevents them from making a decision, is that they are concerned about P becoming homeless if they make an order. You don't have that problem in the Court of Protection because, as I say, as a matter of practicality, you have to go there with an alternative. And what that also tends to mean is that there will have to be a joined up approach between housing and social services. Housing may have a limited role here, not least, as I've mentioned, that the homelessness provisions are unlikely to apply. And so accommodation may often be provided by social services by securing accommodation under the Care Act. So you have to get that joined up approach between those two different arms of the local authority. Next slide.
Michael, just John, just to say you've got 2 minutes.
Yeah, can you show the next slide, Georgia?
Sure.
Yeah, so just very briefly, I've been talking about the benefits of going in the Court of Protection, but there, as any of us who have been in the Court of Protection know, there's also many downsides. Not least, although the county court often finds it very difficult to make decisions in these sorts of cases and adjourns, that can be a problem in the Court of Protection as well. However, I think if you keep the Court of Protection on acting within the proper legal framework, then that can help. The last bullet point here mentions the case of A versus A, Clinical Commissioning Group, Supreme Court decision from 2017, and it makes the point that the Court of Protection can only make decisions which would be available to P if he had capacity. In other words, if the options put before the Court of Protection are limited to accommodation X, current accommodation, or accommodation Y, the alternative, then the Court of Protection cannot say, well, we want Z, or it cannot say we want Y plus plus plus. It has to make a decision on the basis of what the public body, the local authority, are putting forward. And if it doesn't like that choice, which can sometimes be simply a binary choice of X or Y, then the remedy is not in the Court of Protection. It has to be by way of judicial review. And if you keep the Court of Protection operating within that framework, then I think that can greatly facilitate speedy and expeditious decisions in the Court of Protection. So that's all I want to say about these slides.
Peggy, if I can invite you to take over.
Yeah, sorry, Claudia, I was busy reading the questions, which are very good questions, but I will now move on. If you could go to the first slide, please, Claudia. Right, why does the COP need to get involved at all? I mean, Michael's given us the broad framework. So the main point I want to get from this slide is that the Mental Capacity Act allows us, or allows people to make best interest decisions in relation to P, where they lack capacity, except where it involves signing a legal document. So when they have to sign a tenancy, a legal document, you must get authorization in another way, whether this is by having a lasting power of attorney, if you're an individual, if you're a deputy, for example, a finances and affairs deputy, or if you've just got a specific order on a discrete point that allows you to either enter or terminate a tenancy on behalf of P. Next slide, please. Next slide is the role of the COP and the role of the county courts. I mean, John also touched on this, and I just want to again emphasize the different roles of the county court and the, to the COP, very different courts indeed. The county court is more directed at assisting you in your housing management functions in dealing with these incidences of ASB, whereas when you move over to the COP is solely looking, as John says, at the best interests of P and what that is. And it is very difficult when people move from a housing possession case over to the COP to conflate or to not tease out those differences in approach. And I just wanted to show that we did it. So when we were setting out what the tagline to this talk would be, we said, how can the COP be persuaded to decide that P should surrender his or her tenancy? That's very evocative of what one does in the county court. You persuade the judge there that there should be a possession order, whereas in the COP, what the judge is looking at, is there a lack of capacity, and it is in their best interests to grant an order that you terminate the tenancy. Not on the slide, but I also wanted to tease out the role of the COP, because John also touched on this. And so generally in these type of cases, before looking at whether there's a capacity issue in relation to tenancy and best interests, the COP will first look at where it's in the best interest for P to reside. And that is their primary focus. And unless and until that has been determined, they are very, very unlikely to go on to look at best interests in relation to the tenancy. So there's very few reported cases on surrendering tenancies because they tend to fall behind or fall in line with the decision that's been made on best interests as to where P resides. Next slide, please. But one of the cases that does look at it is this case of LB, Islington and QR. And two reasons I wanted to bring it to your attention. The first is it is one of the few ones that sets out the relevant factors in that particular case, at least, that go to capacity for surrendering a tenancy, but also because it teases out John's point that P might be understand and be able to use and weigh up the technical elements of the tenancy, pay the rent, don't make noise, take the bins out. But the difficulty might be when they look at their particular circumstances and how that affects their adherence to those obligations. So what happened in QR? Well, Miss QR, she was a middle-aged lady. She had a diagnosis of schizophrenia. The concern of her treating clinicians was that she lacked insight into her illness. She didn't believe she had an illness. She didn't believe she needed to take medication. She didn't see any link between her suddenly ceasing to take her medication and the very rapid deterioration in her mental and physical health that would happen a few days later. And so as a result of that, she would fall into crisis. She would be subject to Section 3 detention, sectioning under the Mental Health Act, and everything would go to pot. In this particular circumstance, she had been discharged from the Section 3 into a step-down rehab facility, stayed there for a while under a CTO, that's a community treatment order, and stabilized there. And so the clinicians were looking for the next step, which was a step down into supported living. But before that could come to pass, she already had an existing council tenancy, and the landlords, or the putative landlords, were like, unless and until you give up, you surrender that tenancy, we can't give you a new supported living one. You just can't have two tenancies. Miss QR didn't want to give up her own flat. She wanted to stay there. She thought supporting living arrangement was too institutionalized, so didn't want to move. And so there was a substantive decision for the court to look at, very unusually, as to whether she should surrender her tenancy. What the court did was that they heard evidence, oral evidence from two psychiatrists. They spoke to Miss QR herself. She didn't actually give evidence, but they asked her questions, elicited information from her. And then the courts or the judge set out the relevant factors to her decision. So you will see as we go through them that there's the core ones. So the obligation to pay rent, for example, to occupy, to maintain the property. That's a core relevant factor that one has to understand, use and weigh up. But as we go down those bullet points, you'll also see that there's some that were individual to her case. And it's in my experience that in almost every case you deal with that gets to the stage of going to the court of protection, they're going to be the individual factors that P needs to be able to use and weigh up in relation to their circumstances that you or your capacity assessor needs to tease out, so they are put to P so she can have the opportunity to see whether she understands them, use and weighs them up. So in relation to QR, there was the basic ones of pay your rent, there was the landlord's obligations to her, risk of eviction if she didn't comply, and the last two, the purpose and terms of the tenancy, which were to provide her with 24-hour support so that she takes her medication and can maintain her mental health. So that was an intrinsic or integral part of that type of tenancy, and that's what she couldn't apply to her circumstances because she lacked that insight into her mental health. I think there's a question on the Q&A as to how can this capacity type assessments be made when mental illness is so multifactorial. And in QR's case, it was her paranoid schizophrenia manifested around having no insight, and manifested around paranoid delusions in relation to her neighbours. But aside from that, she was fine. So in this case, she actually had litigation capacity. You'll hear more from that about Tara, but the assessors in the court were able to distinguish between her ability to give instructions as to how she wanted to pursue her legal case, which is, a fairly significant matter, but she lacked capacity to decide whether to surrender her tenancy because she lacked that insight into needing medication to be well, and so being in that type of accommodation. Next slide, please, Koljit. So this one lists the relevant factors for her as to how to surrender her secure counsel tenancy. She had put forward that, well, if you don't want me to go to my flat, I'll have a management transfer and go to another flat. And so that's why this first bullet point was a relevant factor for her to understand that if she surrendered it, then she couldn't undertake a management transfer and exchange that tenancy. She also had to understand that she couldn't move to a less restrictive environment than where she was unless she gave up her tenancy. So she didn't like the institutional nature of where she was and a supported living placement, but she would never get to what we call bare accommodation. She would never get to a normal flat without any supported living criteria bolted onto it unless she went through this step-down process that she couldn't understand. For the foreseeable future, the terms of her CTO wouldn't permit her to live in the flats, also couldn't take that into account, use and weigh it up, and that she needed 24-hour support in her accommodation in order to remain well. And that also giving up a tenancy did not preclude the grant of one in the future if she was well enough. So again, her concern was she wanted a normal flat, but she couldn't hold in mind that, well, if she went through this stage process, eventually, touch wood, she might get there. So all in all, the judge determined that she lacked capacity to surrender her tenancy and enter into another one, and the relevant orders were made. Next slide, please, Koljit. Best interest to terminate. I mean, this is what John said, and I would only reiterate and agree with him wholly. If you're asking or seeking to persuade the court that it's in P's best interest to have the tenancy terminated, it's not going to happen. It's extraordinarily unlikely to happen unless and until there is another placement, another property for T to go to, sorry, that should be P, for P to go to that's in her best interests. And the difficulty, or the challenge rather, that you'll find in the COP is that the official solicitor or whomever is acting on behalf of P is going to give you a lot of pushback. They're going to want you to explore, you being the local authority, or if you're the landlord, for example, in conjunction with the local authority, if you're a non-unitary authority in conjunction with the social services parts of the authority, or separate authority, want to look at all of you working with P to see how her needs can be met in this property, such that the behaviours that manifested themselves and were then labelled antisocial behaviours no longer manifest themselves or are mitigated or are managed. So you're going to get a lot of pushback to keep that property alive until the end of the hearing, or the final order, as I say there. I think a question was asked about that. Court of Protection possession cases can take, my experience, longer than possession cases in the county court. You're looking at 9 months, 1 year plus to get to the end of a hearing, a final order. And so in that time, you may be trying to manage any antisocial behaviour if P has remained in the property, or if there's been an interim order moving P to another property, then that property is empty effectively, is what you do in that situation. So I just said in the last bullet point there, the issues of housing management and the effect on neighbours are part of the context, but what the COP looks at them is that they used to illustrate where the care need, the unmet care need is. They used to illustrate what support the person needs. So if it's a hoarding case and it's a fire risk is a major thing for the neighbours, but what the Court of Protection is like, what treatment has health given? What psychological therapies has she been offered? What day-to-day management or week-to-week management has a housing officer given her to go into the property to help her tidy up little by little? Has the fire service been in, for example? What all these unmet needs need to be teased out and addressed, and only then, if they can't be adequately addressed, will you get an order that P lives elsewhere, and then your order terminating the tenancy. Next slide, please, Koljit. Right, so the tricky issues that you will find when you move over from the county court to the Court of Protection. The first was that a length of time that I mentioned. One way of trying to circumvent that is that one can make an application within the proceedings for a court to make the orders terminating the tenancy before the end of proceedings. Rare that happens. I just mention it because it is an option. It generally happens where, for example, the landlord is a third party, non-public body, non-social housing landlord, and so the court has no leverage over that landlord or placement provider to kind of keep them on side, or to hold the ring. So in those kind of situations, such an order may be made. Also, an order may be made on an interim at an early stage where it's really obvious that the property just simply isn't suitable and cannot be made suitable. And also where the local authority or the landlord can put forward evidence to say that, look, this is it's a placement for vulnerable people. We've only got, a finite number, and we've got an infinite number of persons that could benefit from it. And by holding it empty for the year that these proceedings were going on, you're really disadvantaging all those other Ps that I have to look after. Sometimes those types of arguments work to shorten things. Other problem is if P is not actually in the property while this Court of Protection case is ongoing, who's paying the rent? The tenancy agreement is still there. P is still obligated to pay rent. The main thing that we look at is that if P is in a care home or a hospital type accommodation, they may benefit from the housing benefit rules that allow housing benefit to be paid for up to 52 weeks. So definitely explore all your housing benefit options and explore creative solutions. So with that 52-week, in one case I had, P was in rehab for an extremely long time. We were coming up to the 52-week deadline, and it was seriously considered in that case, and would have happened but for something else happening, that he would be discharged home for a very, very short period, and that would re-trigger the 52 weeks, and then he could go back to hospital. Because in that case, he had waited a long time for his property. It had been extensively adapted to meet his needs, and the OS, the official solicitor, didn't want the property to be lost as a result of rent arrears, or indeed for P to be subject to this huge debt that he was may have faced through no fault of his own. Other options that the court look at, the local authority to agree to cover the arrears. I think John may have covered it, or may have been covered in his slides. This is the public law decision for the local authority to make. Resist where possible. But as Michael pointed out, sometimes you're before a High Court judge who can wear his admin court hat and his court of protection hat, and he can use that as a persuasive tool to effectively give the nod to local authorities that if they don't agree to cover the arrears, so P isn't subjected to a debt or at risk of losing his property because of rent arrears, then that public law decision not to do it would be found irrational. Generally, in cases where it's happened to me, is because the local authority have perhaps, on the court's view, not abided by all their statutory obligations that they ought to have done under the Care Act, or there's been delay, or there's been, hedging and hadging. And so it's not necessarily P's fault, or could be perceived not to be P's fault as to why these rent arrears are increasing. So therefore the local authority should cover them. More generally, the landlord, particularly as a social housing landlord, agrees to write off the arrears for much the same reasons. P is vulnerable, and where the antisocial behaviour or the manifestations and behaviours that resulted in that label of antisocial behaviour are due to the disorder and therefore not their faults, is it right, to hold them to this debt? And so that's where you have negotiation, persuasion outside court. And that's where what John and Michael were referring to, the non-adversarial nature of the court of protection, helps, because you're sitting around the big table, pre-COVID, of course, sitting around the big table, and you're discussing the best way that all parties and stakeholders can help P in their best interests, to resolve the situation, to reduce the needs for eviction as a result of the perception of antisocial behaviour. Another tricky issue is placement provider wants to evict P. This type of scenario is where it's a supported living placement. So you may be aware that you have the supported living, the care provider, and then you'll have the landlord, and technically they should be separate. Generally, there's links. And so trust may have broken down between the placement provider and P because of challenging behaviours. They may feel they're no longer able to meet his needs. They give notice of cessation of the care package. And if that ceases, then the property also falls. They're generally independent third party. Local court doesn't have much leverage over them. If that happens, then generally you'll get the order to terminate the tenancy at a much earlier stage, because they say, well, he's simply not coming back, we refuse to have him back, and there's nothing the court can do to gainsay that. What sometimes happens in those types of cases, and could happen if, for example, you act for a housing association, or if you act for the authority that the housing authority that's a non-unitary authority, is that you may yourself instruct either solicitors or counsel to either go to court or to write a letter setting out your position that the court will take into account. The court will take it into account. They want as much information as they can possibly get as to the pressures that landlords are facing, because they know there are pressures, and as to how the landlords have been working with the other statutory bodies or non-statutory bodies to work in P's best interest. So that is an option out there. It's in that sense, it's fairly informal. And for example, I recently had a case where the placement provider instructed counsel to come to the hearing, non-parties, but the court will give you permission to attend the hearing for the purposes of providing information that will best assist the court to make the right decision. So the courts in that court of protection in that sense is very flexible as to their case management functions. I think, Claudia, that's the last slide. And if that's the case, I'll hand over to Tara. Thank you.
Hi, sorry, just trying to turn on my camera. Hello, everyone. Claudia, if you can flick on to the next slide. John, thank you, very helpfully earlier explained that very often landlords might find themselves with a choice as to whether or not they are going to proceed down the county court route or would consider alternative proceedings in the Court of Protection. So I'm talking about the county court. I suspect many of you might be a little bit more familiar with this jurisdiction than with the Court of Protection. I think really what I'm going to talk about today is circumstances where you have decided to go down the county court route knowing that there are going to be some issues with capacity for whatever reason. or alternatively, you have commenced proceedings and then it subsequently transpires that there are problems or questions around capacity. Now, the key distinction here is what has been repeatedly said already today, that the Court of Protection jurisdiction is non-adversarial. I always think about the Court of Protection as being focused on problem solving. What is in P's best interests, and how can we all work together in order to find the best solution to meet those best interests and make sure that their needs are taken care of. Obviously in the county court that's not the case, and whilst there are duties to cooperate and important public law duties, in particular those arising under the Equality Act and the Public Sector Equality Duty, we are in a litigious environment, and I think I've kind of thought about my remarks today in circumstances where the issue of capacity is very often going to be in dispute, and if capacity is not in dispute, then there may be dispute as to what a lack of capacity means, or to what extent that actually restricts P in their actions and also their landlord in terms of what remedies are available. Now, I've only got a few minutes. I notice we're running a little bit late already. I would preface my remarks by making everyone aware that Peggy already wrote an excellent article on this subject a few years ago, which is called Antisocial Behaviour and Mental Capacity Assessments, Practical Questions Answered. And pretty much everything I say, she covers in more detail than I'm able to today. I know that's somewhere on our website. I'm not exactly sure how you can find it on the website, but if you just Google Peggy, Antisocial Behaviour and Mental Capacity Assessments, it will come up. It was written about 4 or 5 years ago, so just do bear in mind that you might want to check the procedural rules in case they've changed, and there'll probably be some newer case law as well. But I would highly recommend anyone to look that up. What we're talking about are claims for possession, claims for injunctions, or the committal proceedings to enforce injunctions, which might subsequently be brought. The headline point is that the Mental Capacity Act 2005 also applies to the county courts. I've headed this as county court because that's normally where you'll be, but of course, if you ended up in the High Court for any reason within injunction or possession proceedings, the rules are the same. And so you need to bear in mind the tests for capacity, which are set out by sections 1 to 3 of the Act, and the general guidance and principles on capacity, which are set out there. And that is because of CPR 21, which sets out the rules which apply to protected parties. And protected parties are defined as children under the age of 18, but more importantly for today's subject, people who lack capacity to litigate within the meaning of the 2005 Act. And that's where the link to that Act comes in. And it's why the county court district judges or circuit judges will be concerned with the application of the Act and the principles such as a person must be assumed to have capacity unless it's proven otherwise. Now that's a very important definition, and I've given you the reference to CPR 21.1 subsection 2, because it's notable that a protected party is only a party who lacks capacity to litigate. That definition does not extend to people who lacked capacity in other domains, in particular to those I've set out there at the bottom of the slide, specifically capacity to comply with injunctions or to give undertakings, or the capacity to comply with the terms of a suspended possession order, such as possession orders may not be enforced as long as the defendant complies with certain terms and conditions. What's important to bear in mind is that we are always concerned with the specific questions that apply to the capacity assessment. We never look at capacity as some sort of global subject. Peggy, I think, talked about this quite well, and in particular on the Islington case, where there was quite a bit of detail about the different sorts of decisions that persons could and could not enter into. The more likely scenario is that somebody would lack capacity to litigate, but would have capacity to comply with an injunction or an SPO, on the basis that there's different tests and there's different case law which applies to assessment of capacity on those points. Litigation relates to the ability to instruct solicitors to perhaps weigh or assess or use the advice and information provided to you by your solicitors, to for example, not to be unduly influenced by your solicitors because you would give their advice too much weight, to understand cost risks, to be able to enter into decisions about whether or not to agree a settlement of the proceedings. Now, whilst I'm not saying that is a very high bar, at the same time, that is slightly more complicated than the question of can you comply with an injunction? And many of you will be familiar with the case of Wookie. It's very well known. It's a family law case. What that said was basically that an injunction should not be made against somebody who does not understand the injunction, or what they are required to do to comply with the injunction, or the consequences of what might happen to them if they fail to comply with the injunction. And there are two reasons for that. One of which is, in those circumstances, the injunction could not deter their behaviour, in the sense of they would be unable to understand that they need to improve their behaviour going forward, and also because they wouldn't be able to be committed if they breach the order. And so it cannot be just or convenient to grant an injunction in those circumstances. The case of P&P I've also provided reference to because it's quite helpful. It confirms Wookie, but it also clarifies that it's not necessary to show that the person had a willful intention to disobey the court order. They only need to know that what they were doing was prohibited and that it could lead to their imprisonment and arrest. And Peggy's article deals with this quite well in terms of the sorts of questions that a court should be asking when considering capacity to comply with an injunction, or I think also with the suspended possession order, where the principles will be very, very similar. All P needs to know is, well, what is this injunction? What am I required to do in order to comply with it? And what will happen to me if I fail to comply with it? Similarly, I think for an SPO or possession order, the questions will be along the lines of, well, did these allegations of antisocial behaviour take place? Will they continue to take place in future? Was the antisocial behaviour linked to their physical or mental health condition? Do they want to give a promise to the court that they will stop that behaviour in the future? And do they understand the consequences if they fail to comply, such as I might lose my home? Now, those are not very complicated or difficult questions. I would say it's a relatively low threshold for someone to understand those issues. And to give you a practical example, I dealt with a case where somebody had paranoid schizophrenia. He was assessed to lack capacity to litigate because his paranoia and suspicion of other persons meant that he couldn't instruct solicitors, he couldn't trust his solicitors, he was unwilling to share information with his solicitors. But he was assessed as having Wookie capacity because he was well capable of understanding that he needed to do certain things or stop doing certain things, and what would happen if he didn't do them. And the fact that he believed that order had been made against him as part of some conspiracy against him was neither here nor there. He was capacitous in that respect. And so I think that's why you'll often end up in a situation in these cases where there's dispute about what capacity means, and it doesn't necessarily mean that you are limited in the remedies that are available to you. Conversely, if it becomes very clear through the course of the proceedings that the person cannot understand an injunction or comply with it, then those remedies are taken away from you. You cannot make an SPO, you cannot make an injunction, and it would become a binary decision between whether or not it is reasonable or proportionate to make an outright possession order. And the facts and circumstances and severity of the antisocial behaviour would be very important in terms of any assessment for that. That might be a situation where it's worth thinking about perhaps transferring proceedings to the Court of Protection or beginning separate proceedings there. So I go on to the next slide. I'm going to move through the rest of the slides, I think, quite quickly, but at least I've provided you with some practical information to think about within those slides. An important point is that any protected party who is a person who lacks capacity to litigate must have a litigation friend to conduct the proceedings on his behalf, and any steps taken when a person lacks capacity to litigate without there being a litigation friend are automatically null and void. Now, that can be catastrophic. I've drawn your attention to the Dunhill and Bergen case, which was a personal injury claim, and some 6 years after the claimant settled her claim by way of an award of damages via a consent order, she obtained new solicitors, ultimately an assessment and then a declaration that she had lacked capacity at the time she entered into that settlement. And many years after the event, the consent order was set aside and was nullified. Now, in the context of a housing case, the worst case scenario that you might face there would be that you issue a possession claim, you get an outright possession order, you evict the defendant, you re-let the property to a third party, and then 6 months down the road, it turns out that the defendant lacked capacity and your possession order is set aside. And the landlord could find itself in very considerable difficulty in trying to grapple with that situation. So the relevance to an antisocial behaviour case is, please do not progress the matter if there are genuine concerns by any party to the proceedings about the defendant's capacity. And there's case law which suggests that there's just as much of an onus on the claimant landlord to bring that issue to the attention of the court as there would be upon the defendant's legal representatives themselves. So address it early on, please. Next slide, thank you. These are the procedures which can be used to appoint a litigation friend. It can be done without a court order if the person certifies that they can fairly, competently conduct proceedings on behalf of the protected person and have no interest adverse to that of the protected person. Alternatively, if you, there's a procedure whereby the court can appoint the litigation friend, or the litigation friend who's self-appointed themselves perhaps could be challenged. I think all that I would just say about that is, first of all, if there's no one suitable who's willing and able to act as litigation friend, the official solicitor can and should step in. There's no procedure for doing that. A claimant landlord can simply write to the OS and invite them to get involved, and the court can make an order appointing them as litigation friend. If you have any concerns about the person, somebody who wants to be litigation friend, and you're concerned about their suitability, the obvious scenario that might arise is where the litigation friend themselves lives in P's property and might have a vested interest in, if essentially they might lose their own home if an order for possession was made against the defendant, for example. And so you might have concerns as to whether or not they are entirely self-interested in the way they're conducting the matter. I'm going to skip over it, but just to draw your attention to the fact that there has been some recent case law on recovering costs. If costs are awarded against an unsuccessful defendant, there are some circumstances in which you might recover those costs directly from the defendant's litigation friend rather than the defendant themselves, particularly if there's been some sort of unreasonable behaviour. So that might be a useful power to know about. The next slide. Some practical considerations. Well, I've already made the point that you need to think about this quite early on by the claimant. Obtaining capacity evidence, the first point is it must address the tests from the 2005 Act. A letter from a GP which says this person's very vulnerable and therefore doesn't have capacity is not going to cut it. The fact that a person might be vulnerable and need a considerable amount of assistance within the proceedings doesn't necessarily mean they lack capacity. The fact that they might be illiterate, for example, and would need help in dealing with the matters and communicating with the court means they might need a solicitor or a Mackenzie friend, but it doesn't mean they lack capacity. The gold standard would be a single joint expert report completed by a consultant psychiatrist. You can also have single joint expert reports by psychologists and social workers, but also if there is already ongoing social services involvement, then the local authorities appointed or allocated social workers or community mental health teams can conduct the assessment. I've seen numerous questions already coming up about what happens if the defendant cannot or will not engage. And that's a really difficult question to answer, but because it has come up in Q&A, and despite the fact that we're now at 4 o'clock, I'm just going to briefly say a few key points, one of which is that ultimately the defendant cannot be compelled to attend or to undergo assessment. If they do not want to do it, the court does not usually have power to detain them or to otherwise compel them to do it. But the advice has to be try and try and try again and try it by various means. If there have been numerous attempts to engage with the defendant and they're just not having it, a worst case scenario can be that the social services team might be able to conduct an assessment on the papers by having looked back over the person's medical records or social services records. That's really a last resort and isn't at all preferable without there having been face-to-face contact with the defendant. But as a worst case scenario, it's an option. The claimant could consider simply paying for an independent expert themselves if the defendant would be willing to engage with it. The claimants should be doing, I think, everything they can to try and get the defendant a solicitor. That's not normally something that forms part of your duties, but it would certainly make it much easier to deal with the case if the defendant was represented. And then there is an unusual power if you are dealing with an injunction. If someone has been arrested for suspected breach of an antisocial behaviour injunction, there are powers under Schedule 1 of the 2014 Act to remand the person into custody for a period of a few days for the purposes of a medical assessment. So I by no means say that anyone should be arrested without there being reasonable evidence to suggest that they have breached the injunction. But if you find yourself in that situation, that might be an opportunity to get someone to try and meet the defendant while they're in police custody. I've dealt with at least one case where that was where that happened. The assessment that resulted from that was not particularly detailed or useful, but it did give the court some reassurance that efforts had been made to assess capacity. And finally, you know, it does remain the case that we assume there is capacity unless proven otherwise. And so at the end of the day, it may come to the point where the court simply goes ahead on an assumption of capacity because the defendant has not undergone an assessment. if there is evidence that the defendant is trying to stymie the proceedings by refusing to engage, thinking that they will save themselves from possession, that might be relevant. It would also be important, I think, to give the defendant a clear warning that they are potentially putting their home at risk in those circumstances before asking the court to carry on. And the case with authority for that is Baker, Tilley and Makar, where a judge who was really concerned about the defendant felt compelled to find that there was a lack of capacity, and on appeal that was struck down and said he didn't have authority to do that without evidence and support. I've already talked about the identity of a suitable litigation friend. On the final slide, without getting into it very much, if we can flick forward, just to say there will be considerable overlap in all the things I've just suggested, trying to get help, support and assessment of the defendant. Those are not extra things or wasted efforts. Those would squarely go towards compliance with the Equality Act and the PSCD. You will be able to show that you've clearly had potential disability at the forefront of your mind throughout the way the proceedings have been litigated. So do bear that in mind and do document everything as you normally would do, and add that into your proportionality assessments at the end of the day and coming up to your hearing. So I've run over, but thank you for indulging me, and I can see that there is plenty of activity happening on questions and answers and so on.
Thank you very much, Tara, and to the other panellists for very informative talks. The panellists have sought to answer your questions as they've been going along, either in their oral presentations or in a written format. I'm very conscious that we've overrun, but having checked with the panellists, they are happy to stay online to answer any questions that you might have in written form. But before I close off, if I could just check with the panellists, does anybody have anything that they'd like to deal with in oral format before we sign off?
Can I mention something about section 49, Kuljit? Because looking at the questions, a lot of questions have come up, as Tara just mentioned, about the difficulties of getting capacity assessments done. One of the additional benefits of the Court of Protection is that under the Mental Capacity Act, section 49, it does have the power to require someone from the NHS, or indeed one of their own special visitors, to do a report on capacity. And that therefore is then it's an instruction that goes to, say, the NHS, and the NHS has to do it. The local authorities or the parties to the proceedings don't pay for it. So it's quite a useful way of addressing the issue of capacity. Sometimes it's frequently overused, I think, when particularly the official solicitor tends to ask for reports under section 49, which are not required. But if you have a genuine issue about not knowing if someone has capacity to make a particular decision, then that can be a very useful solution.
Just connected to that, John, there's been a question come up on the Q&A about housing officers doing assessments, and I wonder if you'd like to maybe say a few words about that.
Yes, I mean, you don't, I mean, to decide on capacity, I mean, anyone who's competent to understand the test in section 3 can do it. So in principle, there's nothing to prevent a housing officer from making an assessment on capacity. Obviously, the officer should set out the test and make it clear that he or she has addressed those 4 issues that I mentioned earlier thoroughly and fairly. But there's no reason in principle why a housing officer can't do it. Most of the cases I get involved in, you have capacity assessments done by social workers, and they're normally fine, even though the official solicitor will quite often find problems with it. But in reality, you know, social workers' assessments of capacity are normally fine.
And it goes back to your point that if there is an issue with the quality of the assessment, then the court's got the power to direct a section 49 report, or the parties can agree that further capacity evidence is needed. But there isn't any formal requirement for somebody to have medical training or indeed any sort of training in order to conduct a capacity assessment. And so housing officers, social workers routinely provide capacity assessments. It isn't the case that you have to get a consultant psychiatrist or some other specialist doctor. I'm going to wrap up by saying that we'll endeavour to answer the remaining written questions in the next few minutes. If I could remind you all that of the remaining events that are taking place this week, do take a look at our website, and do please, when you get the request for feedback, particularly in relation to further topics that you'd like us to cover, do let us know, and we'll do our best to try and accommodate those in the forthcoming timetable. Thank you very much to all the participants. It was a very informative session, and I'm going to sign off.